An omission is failure to act, and the general rule in English and Welsh law is that you're not liable and you have no actus reus if you fail or omit to do something. Um, so if you saw someone drowning, for example, and you just walked on by, like our friend Felix the cat here, um, you wouldn't have committed any offence because failing to do something can't be an actus reus. Now, some countries have a Good Samaritan rule, which means that their citizens are expected to at least attempt to help or to call for help, but we don't have anything of the sort. But we do have some exceptions to this general rule on omissions, because it does seem a little harsh and lacking in moral fibre, if you like. Um, and these are situations where a person has a duty to act and where their failure potentially could mean that they do have the actus reus. We're going to look at each of them in turn. The first exception to the rule on omissions is when there is a statutory duty to act. This is because sometimes an Act of Parliament will make a failure to do something, an omission, a criminal offence. Let's take an example. Let's say you're driving along and you see a car that's crashed into some trees. And instead of reporting that accident, you just drive on by. It is an offence to fail to report an accident, to omit to do that. So we can see there are some statutory duties that make a failure to do something the actus reus of a crime. It's also an offence to fail or to omit to disclose knowledge of terrorist acts or the funding of such acts. So if you knew that someone was involved in terrorist activity or you knew that someone was funding those acts and you failed to tell somebody, then your actus reus could find you guilty of an offence. There's all sorts of driving offences like failure to provide a breath sample if you're stopped by the police. This can find you guilty of a criminal offence, as well as failing to care for a child. So there are lots of statutory duties to act that break our general rule on omissions. Our next exception to the general rule on omissions is where the defendant has a contractual duty to do something and fails to do it. Most people's job contracts state quite clearly the sort of duties they have and what they should not fail or admit to do. The most famous case on this is the case of Pitwood. Now, Mr. Pitwood was responsible for opening and closing the railway crossing gates, and he failed to do this one day, and a train collided with a horse and cart, and the train driver was killed. So in this type of situation, because he had a contractual duty, it was part of his job, and his failure to do it resulted in a death, his omission could find him liable and did count as an actus reus in this type of situation. The third exception to the rule on omissions is where there's a duty because of a relationship. Now, this is generally a duty towards a child, and a failure on the part of the defendant to act might find them criminally liable if something happens to that child. Now, this could be neglect, not feeding that child properly, or putting them in dangerous situations. We have the responsibility for that child, and if we fail or admit to do what we have to do, then potentially that omission or that failure can be the actus reus for an offence. I'm often asked by students whether this applies between siblings as well. They might have younger brothers or sisters, and this duty doesn't really apply because of a relationship here. But as we'll see in a bit, it does apply if you've taken on the duty. Now, the fourth possible exception to the rule on omissions is where a duty has been taken on. This could apply in a number of different situations, but the classic one, I suppose, is if you decide to take on the duty towards a relative. This could be an elderly aunt, your sick father. And in that type of situation, if you take on that duty and then you fail or omit to carry it out properly, then your failure or your omission can be the actus reus if something untoward happens to that relative that you've taken on. Um, if let's say you stop at an accident and start to help somebody who's seriously ill there, and then you decide to move on without doing anything about it and leaving them to whatever's going to happen to them, then once again, this is potentially a situation where you have taken on a duty and then failed to carry it out properly. People might say, doctors on a plane, beware. The fifth exception to the general rule on omissions is those defendants who have a duty through an official position. We've already seen that some people have a duty because of a contractual obligation. It's clearly stated in their job what they shouldn't fail or omit to do. But the courts have recognised that there is an expectation that people who serve the public, a police officer, a fireman, a teacher, a social worker, have a duty at all times, even when they're outside their job, to make sure that people are safe. And so if a fireman, for example, were to fail to report a fire he'd seen just because he was off duty at the time, the courts may well see this as an omission or a failure on his part that could be the actus reus of a crime. The sixth and final exception to the rule is a duty where the defendant has created a dangerous situation or set in motion a chain of events. And the most famous case on this is a case called Miller, which all students need to know, law students need to know. And it involves Mr. Miller, who was living in a squat, and one day he came home and fell asleep while smoking a cigarette. When he woke up, he realized there was a fire in the room where he was. And so instead of doing anything about it, he just got up and moved to another room. And he was charged with and found guilty of arson because, of course, he had set in motion a chain of events and then failed or omitted to do anything about it. And so his actus reus, his omission in this case, because he'd started the situation, he'd created a dangerous situation, meant that he could be found liable for the offence of arson. So let's do a quick recap. The general rule in English law is that you are not liable and you have no actus reus if you fail to do something. Unless, of course, you come under one of the exceptions. A statutory duty to act, a contractual duty to act, a duty because of a relationship, a duty which has been taken on, a duty through an official position, or a duty where the defendant has created a dangerous situation or set in motion a chain of events.